Justice Eric Obola, Justice Andrew Rima, and this Justice Frida Gandhi. I've listened to what you have said very carefully. And from my point of view, one who is interested in developing the students of the country, you have done, you have developed. But there is one thing I would like to point out to you very first. That we are operating in very dangerous water. With strong current. And it's an area where we have to call for wisdom. We have called for deeper understanding of human nature and for deeper understanding of the society which will be Kenya. And what I'm saying to you is reflected in my broad reading of the authorities in cases in the United States of America. If I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for a book from India straight about the electoral reforms on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will this judgment be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will continue to promote stability in the country? And it's here that I'm inviting you very specially that you consider the able remarks of my learned friend, Mr. That we should not, and grant very much.
Only it's one-sided.
We should not ignore what they are saying back here.
But let's go. I finished enough.
We don't want to move out of this courtroom.
Let them go to data the
And then all of a sudden I told that we have protest now. I'm not trying to.
Just hold on.
All that I'm saying to you,
Sorry, my lords. The utterances by the Honorable Dr. Hamino, Council, are. I'm giving you the title, sir.
No, what I'm saying, let me say what I'm.
Unfortunately, they're insightful, they are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. Unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor. Sorry.
We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter, and we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dadlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond, and then we'll make a ruling.
Thank you.
I thought I was also that you indicated that two people, and I was prepared pending to make an application.
Continue, Dr. Kamuna.
You know, I'm actually, it's only one sentence. When you read the book, I have referred to authorities in America. The judges have made a finding along these lines. Yes, this is the people. So and so is guilty. But we shall not go ahead and do that. We shall be him. So that's all I'm saying to you. You have heard, you have come up with a very family say so, a ruling full of jurisprudence, and particularly my landlord, Justice Lima, has come up with something that I had not thought of very much at all. But all I'm saying to you, that you agree, but you still have the discretion to say that, look, we are not, we have these are our findings, but still we are going ahead to give conservative orders for so many days or so many weeks. So you still have that discretion for the sake of the country. Thank you.
My Lord, may I kindly, my name is Sam Meberi. I appear for the 9th petitioner in the second cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, my Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord and my Lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition we had named the Professor Kibura Kindiki as a party in the petition that we had filed for the 9th petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill out that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time, we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the 9th petition. Thank you, my Lord.
My Lord, I would like to make an application under Article 1.1 directly. And my lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and court case that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we'd be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November. So at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that the regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners and others will just be thrown under the bus and into the darkness. Thank you.
If I may respond.
Can you just clarify, your application says dated the 8th of October?
8th of October 2024. It's petition E541 of 2024, who was seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Maybe with your kind permission.
Let me clarify. Is that the matter which you are planning with Dr. Bosso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You are petitioners in cohort number 1. And we directed everybody to get into the CTS system, and whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in this proceedings. You have been enjoined. You are a party, and that is why we allow Dr. Bosso to address the court, even yourself.
Yeah,
So you are a party. You are a party. That one I can assure you.
My lords, we were not entitled to the right of enjoinder, and we had points that we wanted to defend against the respondent's side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week, after the swearing in would have been gone through, and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we're so sure you are not discriminated because there are proper directions in respect of every cohort and every matter before us.
My lord,
kindly take time to go through the city.
My lord, I offer to assist her.
Thank you. This court had made directions on this issue. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications. We are finished with this side.
You have not spoken on behalf of the second petitioner.
My lord, that we would like an opportunity to respond to both applications that are being brought today.
Maybe I can say one thing, just on behalf of the second petitioner. My name is Kimoto Wanjiru Makazi. Yes, there's Kimoto in company.
You're joking.
We welcome the however, there's some bits that we feel aggrieved and we wish to appeal. And therefore, as we do the notice of appeal, we're praying that we are in support of the issue for injunction. No, the issue for stay, which the court may say it's a legislative order, but we are saying pending the time we do the appeal, at least the status quo be maintained. And also we wish to say that there was an issue that the Court of Appeal today dismissed an application for stay. That is not true. We were told to serve, but we were not all served, and that's the reason why we were given another date. So therefore, we are in support of these two applications that have been made today.
Let's continue also.
Yeah.
Mr. Dr. Bosso.
Yes.
Please sit down. Please sit down.
My lord, this court.
Please sit down. Please sit down.
Will I be given a chance to speak?
Please sit down.
Give it to Wanjiku. Let her talk.
Yes, my lord. As a young woman, I'm under 35, my lord. I'm actually 35. I'm a youth and I have a disability. And we're the owners, I think, on the platform that check that we have a disability, my lords and my lady. Our constitution, Article 1.1, has to count for something. Because it was intended for us to come to court directly.
Please
when we feel
respond to the
affected.
application. Support. Make the application.
Yes, my lord, I'm in support of the application. Most obliged.
My lord, finally. My lord, in response to the two applications.
My lord, there are 3, not 2, actually 4.
But they say the same thing. They say you had what to do. There are 2.
Yes, my lord, in response to the application by my learned friend, Mr. Ochel, future senior counsel, and my learned friend, Mr. Wanjiru, I wish to say as follows, my lord. Number 1, the Matthew paper order sought by my learned friend fall on the basis of the following principles. Number 1, my lord, there is already an appeal that has been filed in the Court of Appeal, and an application for stay under Rule 5 to be filed, being application number 554 of 2024. The Court of Appeal is therefore seized of this matter, already seized of this matter. In those circumstances, my lord, a party can only apply for stay in the Court of Appeal. That's point number 1. My lord, point number 2, ordinarily, when a court delivers a ruling in a matter, the court becomes functus officio in respect of that particular matter. My lord, that matter therefore, or the applications made are therefore res judicata, in the sense that a determination has been made, and this court cannot go back and approbate and reprobate at the same time. You cannot deny an order and then purport to issue the order again. Point number 3, my lord. My lord, rules 23 and 24 of the Mutunga rules as presented before you, together with an application by my learned friend on substantive issues touching on actions that may be undertaken subsequent to this, including, my lord, the qualifications of the Deputy President nominee, Kithure Kindiki, can only be brought to this court, my lord, through 1, either a new petition and a new application, or 2, my lord, through an application for review. The only avenue that Mr. Ndego can bring all the issues that he has spoken to this afternoon are application through review. No application for review or setting aside has to be filed before this court by Mr. Ndego. And therefore it is inconceivable, my lord, that this court would entertain the application brought on several grounds, my lord, including grounds challenging the suitability or otherwise of the Deputy President nominee. My lord, lastly, and because my learned friend will submit further, once a court has delivered a ruling, my lord, the justice of the cause is that consequential processes can be undertaken given that there are no orders in place. And that is not for the court to be part of or to control. That is for other parties, probably not before this court, my lord. My lord, what you have done is dismissed the application of conservatory order. So that's a negative order. If the court cannot be invited to review or to stay a negative order that has dismissed an application. And the negative order again goes to the application by Kimodo and Company Advocates from Kerugoya, who has also sought to stay your orders. Yet, all that application had, my lord, was for the former deputy president
To apologize.
former underlined, to apologize to NIS. Surely, Kimodo, you can do better. My lord, I'll invite my friend.
You are protected. You are protected.
Right? This is Kimodo and Company.
Yes, my lord.